Hi, this is David Bliven, Bronx and Westchester divorce attorney, with another episode of Lessons from the Divorce Wars. So this lesson comes in where I've had a few clients recently get frustrated at the other side attempting to delay the contested divorce proceeding. So the other side will just delay getting financial records over, or getting financial information, or delay paying for appraisals or expert witnesses or whatever else. And the usual rule is that a judge will not certify a case, quote unquote, trial ready until all pretrial disclosure has been taken care of. So that usually means exchange of years of things like bank statements, credit card statements, things of that nature. The parties have had depositions. Usually at the depositions, there's additional demands for documents that are done, and people have to produce those, and all that takes a lot of time to get done. So one of the number one ways that another party can delay a case is just refuse to give those records over, or give them over in dribs and drabs. Like they'll, if you ask for 3 years worth of records, they'll give 2 years. And, I've had other cases where I demand 3 or 4 years or 5 years worth of records, and they'll produce the records, but then conveniently enough, there's months that are missing here or there and just sprinkled in. And then their attorney will say, well, gee, I gave you everything. You didn't get it? I don't know why, and play games like that. But then that causes frustration for my client because, you're not getting resolution on your case. You're having to pay me to keep appearing in court every 2 months saying to the judge, yes, gee, sorry, the disclosure still is not done yet. We can't proceed to trial. So to some degree, there's only so much an attorney can do to speed up the process. We can file motions to compel disclosure. We can file motions for conditional preclusion of the other side from further contesting the financial issues. We can file motions for financial sanctions against the other side. But sometimes the judges are reluctant to grant those motions unless there's really been a pattern of apparent refusal to turn these documents over. So then, the $50 million question is, what does a client do if they perceive the other side is delaying the case and it looks like they're going down the path of a many years long process of a contested divorce? What to do? Okay. So first off, sit down with your attorney. Speak to them. Say, look, I'm frustrated. What can we do? Okay. So if you want financial records, the other side isn't giving them. And I'm not saying this is a great solution. I'm saying it's a solution, okay? Your attorney has the ability to subpoena any documents they want. So if the other side is not producing the documents that you feel you're entitled to, authorize your attorney to fire off a subpoena. If the other side claims, oh, I've given everything that I have, I don't know why you're not missing, great. Here's what I did in a very recent case. I called the other side's bluff. I said, execute a stipulation saying you've given all the documents in your quote-unquote possession or control. Control means I've requested them from the particular financial institution, and this is all that they've given to me. Okay, great. Execute that stipulation because it's done under penalties of perjury, and also provide me an authorization. Because if you execute that stipulation and the authorization, and then I go to your financial institution and I'm able to get the statements that you pledged under penalties of perjury that you could not get, now there's going to be a really clear problem that you're going to have with the judge and possibly with the district attorney, because that's then a criminal proceeding potentially because you lied under oath very clearly. So that's one way to speed up the process. Here's another issue. The other side is delaying payment of appraisals or expert witnesses, like forensic experts. Again, I'm not saying this is a great solution, but it's a solution if you want to speed up the case, which is pay the other side's share. Do a stipulation or get a court order from the judge saying, hey, if, let's say the plaintiff is my client, plaintiff pays defendant's share with a reservation to claim a credit for defendant's share because defendant is apparently refusing to pay their share at the end of the case. That's a way to speed up the case. The appraisal gets done, or the forensic analysis gets done, and you're that much closer to resolving your divorce matter or proceeding to trial. Those are just two ways that I've done things on relatively recent cases to speed things up. There are definitely other ways, but really what you want to do is sit down with your attorney on the given issue and discuss with them, how do I speed these things up? How do I get closer to either a settlement on the one hand or a trial on the other? So those are just some thoughts that I had. If you're looking for answers to very similar questions, you'll want to check out my blog. You'll find it at blivenlaw.net/blog. See you next time.